So I will today talk about the Data Act, an act that deals with data, of course, right? It deals also with personal data, but it does not deal with privacy. That's a quick agenda. I will skip through the first parts because a lot we have already heard, and I would like to really kind of focus about the intersection. So how does it interplay, the Data Act and the GDPR? Because as Dieter Kugelmann already pointed out, it's a bit too easy to say it doesn't affect the GDPR at all. There's certainly an interplay, as you will see. Where do we are? I don't want to go into the history. The Data Act is in place, right? We have it. Here we have to deal with it. It's a very new act, and I focus on that because already during the previous presentation, you learned that there are so many acts right now, which not only the institutions, the legislators, the courts, everyone have to understand, but also the private practice has to understand, the companies. They have to deal with this sheer amount of data, new legislative acts, which makes it really, really difficult. Fortunately, they are given a little bit of time to prepare, but nevertheless, it's an overwhelming resource of new text. So we have got the Data Act. It applies to both, as I mentioned, the public as well as private sector. It's part of the European strategy for data. And the Data Act complements in particular the Data Governance Act, which was already adopted in 2022. Objectives. The European Union, as Dieter Kugelmann already pointed out, understands the importance of data generally, and it wants to promote the sharing of data very effectively. Not every company is supposed to be really kind of collecting the data itself. We want to limit the data collection from a European perspective, but we want to best make use of it by sharing the data and making different market players to share the data with each other as well. That's part of what the Data Act wants. It also wants to stimulate a competitive data market by breaking up certain services, and I will talk about it briefly, and making it more easier to transition to new services provider, and by making data more accessible. A lot of data right now, if you are a consumer, you can already request because they are personal data that's already provided under the GDPR. But there's also sometimes non-personal data, which is certainly not covered by the GDPR, so the Data Act will address this. It's horizontal rules. They are all applying all across the economic sectors and situations. And both the GDPR as well as the Data Act in the end aim the same goal. They share this goal of ensuring the free movement of personal data, but also non-personal data within the European Union. This is what it is all about. I mean, we have to remember this. I mean, also when the directive on the Personal Directive on 95 came into place, it was about the sharing of data without barriers between the different member states. What is data? The Data Act, when you read it, you will see a lot of really bulky, difficult to understand definitions. I cannot spare some of you. I will also go through kind of key parts of the definitions, but won't go into too much detail. But data is really very broadly defined. It means any digital representation of acts, facts, or information, and any compilation of such acts, facts, or information, including the form of sound, visual, and/or audio-visual recording. So it's extremely broad. It does contain also personal data, but the focus of the Data Act is not on the personal data. It's more on industrial data. When I look at the Data Act, I see basically 3 areas which concern the private businesses the most. On the one side, it's the connected product and related services. What is this? Again, there's a very bulky definition of it, but think about it. You have an IoT device, a wearable, for example, a fitness band on your hand. That's an IoT device. It connects with your app on your iPhone or other smartphone. That's a related service. So it connects with it, it steers the information, collects the information, provides some information to use. So that's a connected product. Another significant area of connected products are connected cars right now. When you drive, the car collects a lot of data. Many of the data will remain on the car. And many of this data will be personal data, but many of the data will be also non-personal data. So it's really important for the Data Act to tackle this and to make sure and clarify which data you, as the owner of the car or as the driver of the car, may have in relation to the data. And the Data Act grants far-reaching rights of access to the data. So basically, and I will go into this more detail, if you are a user of such a car, you've bought the car, you're using the wearable, you have against the data holder, which can be the manufacturer, but it can be also another entity kind of providing the services in relation to the car or your wearable, you have a right that they do make the data that you generate with the device accessible to you straight away so that you can access the data directly. And separately, where this is not possible, you have a right to request the data. You have a right to request the data to yourself. And here's right now the data sharing aspect comes into play. You can also request the data be transferred to another third-party data recipient. You can even empower others to kind of make this request for you. And the idea behind is that if companies are interested in the data, they can go in the market, they can reach out to the users and make an offering to pay for the data effectively, to get your permission to request your data from the IoT device for the further sharing purposes. And that will be done based on an agreement to be entered into. It needs to be done on fair principles, basically because also the Data Act doesn't want to disincentivize the collection and use of data. It wants also to grant the ability to monetize the data to the entities, the data holders that create and that have set up the entire scheme to process and collect the data. But it needs to be done on fair principles, and it's also ensured that the data shall not be used for competing services, and that the data shall not be used and get into the hands of the so-called gatekeepers, so the big, very big tech companies in the world, which the European Union believes already have a lot of data. And then we've got the second chapter. It's also extremely important, in particular for private companies, in particular the services provider. It's the data processing services providers. And that's a very difficult definition, but it basically kind of generally entails the PaaS, IaaS system, and in particular SaaS systems. As you can imagine, pretty much all cloud services providers. And what do they need to do? They need to facilitate the easy migration of a customer to another vendor. Meaning, that's the competitive part of it. The European Commission or the Data Act aims to ensure that companies are not locked by a vendor, that you are not locked as a vendor, with a vendor. You can easily migrate to a better offering if you believe so. And then you have got rights for early termination. You have rights for a lot of assistance in relation to the data migration and support. Unfortunately, the Data Act leaves entirely unclear how this actually works in practice. It simply says that the data processing services providers need to enter into agreement providing for all these rights. So it's really left unclear right now what happens if a data services provider does not enter into such an agreement, and what happens with already agreed agreements in place, right? I mean, how to change these agreements? Is there a specific right of the data services processing services provider to reach out to the customers and request a change to the existing agreement, right? Likely the customer would agree to these changes, but maybe not, so because of the conditions. So it's really left unclear how this will work out. We are waiting for further guidance on that part. And then there's a third chapter, which I think is quite interesting, in particular also from a GDPR perspective. GDPR kind of aims, as we all know, to ensure a high standard for the processing of personal data within the European Union, but also outside, right? Because if the data travels outside, it can be then processed in compliance with the principles that we have outlined, and then, makes their way back into the European Union, we have not achieved much. The Data Act tries to aims to kind of do the same for the non-personal data in Article 33 by introducing far-reaching obligations to take all reasonable technical and organizational measures, including contracts, in order to prevent international transfer or governmental access to non-personal data held in the Union, where such transfer or access would create a conflict with European Union law or the national law of the relevant member state. For those of you who are familiar with the GDPR, that sounds very familiar, right? We look at Chapter 5. And in particular, when you look at Para 2, Data Act, it says of Article 33, it says, governmental access to non-personal data held in the European Union may in principle only be provided if based on an international agreement in force. That's pretty much Article 48 of the GDPR. But here comes, right? I mean, privacy law, there we have already a fairly established way of protecting the data, and that is also more and more recognized all across the world, not everywhere, of course not. But this is where we, as you know, the European Court of Justice requires an essentially equivalent data protection standard. We do not go so high under the Data Act because these measures and standards haven't been developed for non-personal data. But nevertheless, the standards are very, very high. It says if there is no agreement, and most times there will not be an agreement, the third country, so it is permissible to transfer data, free flow of data also outside the European Union, but only if the third country system requires the reason of proportionality of such a decision or judgment to be set out and requires such a decision or judgment to be in specific character. So the principle of proportionality, rule of law, also the principle of third country court or tribunal reviewing any such decisions, and the ability to appeal it, taking into account the relevant legal interests of the provider of the data, but also and of the interest, which means basically you need to undergo a fairly complex assessment of whether you can transfer data outside the European Union, of whether your data in the European Union are appropriately protected against any access of by foreign governments. So you're essentially in a very difficult situation with your non-personal data as you are with your personal data. So that's not easy. It will kind of lead to many obstacles, and it will be interesting to be seen how it will in the end be interpreted. But let's not go into the kind of relationship between the GDPR and the Data Act. As I mentioned, the Data Act doesn't want to promote privacy, but it does cover personal data. The Data Act is intended to complement the GDPR, and the GDPR remains, as we already heard, unaffected by the Data Act, which I agree is not entirely right. The GDPR, however, is to take precedence of the Data Act, and that is, of course, very important because we are talking about both regulations on the European level, right? And so there's no presumption that either the Data Act or the GDPR would prevail. So the conflict needs to be resolved by the regulations themselves, which is why it is so clearly stated that the GDPR is taking precedence over the Data Act. The definition of personal data is also referred to in the Data Act, refers back simply to the GDPR. So there is obviously no new definition of personal data, which is helpful for all of us familiar with the GDPR. The Data Act covers both, as I mentioned, and Article 1, Para 5, DA, and also 4, Para 12, and 5, Para 7, but in other areas not, and I will come to this. They kind of refer then back to the GDPR, which helps, right? And recital 34, DA says processing of such data is subject to the rules established under the GDPR, including where personal data and non-personal data in a data set are inextricably linked. That makes sense, right? I mean, where you cannot really separate the data, then which set of rules do you need to apply? Of course, then you need to apply the more stringent rules, which shall not be affected by the Data Act. So it will be the GDPR. However, that means also whenever you have a combination of data sets, in most times, everything, even the non-personal data, will be subject to the very stringent requirements of the GDPR, which means also that you as a company or the public entity will be very limited in the making use of the data, even though the non-personal data before wasn't subject to the GDPR. And it will be very interesting also to be seen when somebody, for example, raises an Article 15 request for access under GDPR, whether this access request would then also cover the non-personal data. Literally, based on the GDPR not, taking a look at the DA, it may be that you effectively have to then render access to the non-personal data as well. Here, unfortunately, you have to introduce a little bit more of the definitions and the kind of key players of the Data Act. And that's a kind of triangular, which is really important to understand, in particular in regarding to the access rights. I mentioned already the data holder, and that is really important in the context of the IoT services. And remember, that is where the data holder has to grant access to the data to the user and or third-party recipients, right? And there's the data holder. The data holder basically is a natural or legal person that has actual control over the data and is in the position to grant access under the Data Act, not more, but it has actual control over the data and can grant access to the data. Then we have got the user. So think about the car. That's you. You have bought the car, the nice fancy car with all the automated systems. You're using the car, right? And so you do have a right against the data holder, a famous brand car that renders the services and that can give you access to the data in relation to the use of your car. But you may have granted, or you may have kind of lent your car to someone else, someone in your family, or if you are an entity, again, your user can be also an entity, legal entity, if you have given it to your employees, right? Then there's also individuals, the data subjects, which have to be taken into consideration as well. Data subjects, something you all know. They all can differ from each other. The user can be the same time the data subject if you're driving the car alone, and if you own the car and you're not a legal entity, then you're the same, right? You're the user as well as the individual, the data subject, but it can be also different, which again brings into the play how this plays out from a privacy perspective. But before we really go into that very question, we need to also understand who's the data controller from a privacy perspective, right? Because the data controller is responsible for ensuring the compliance with GDPR. First and foremost, we would think about the data holder, right? Because the data holder has the kind of actual ability to grant access and is then also obliged under the Data Act. But is this enough to establish the controllership under the GDPR? The GDPR controller is anybody which determines the purposes and means of the processing of personal data. In most cases, this will be the case by the data controller, right? By the data holder. The car manufacturer, for example, has set up the entire services. It has built the car together with many other players in the market, right? But is it controller also in relation to the granting of access? That's a good question, because as we know, under the GDPR, the controller is not a concept which you kind of put as roof on all activities of an individual entity, which has access to data. You have to establish and qualify and understand and assess the data controllership in relation to each individual processing operation. And when we think about the general use of the data, yes, of course, the car manufacturer then would likely be the data controller because it can determine the purposes and means and can work with the data, right? But when it comes, for example, to the request to hand over the data under the Data Act, does it really determine the purposes? I mean, the purposes are set by the Data Act, and it is also requested by the user, who is then obviously has an influential effect on it. It is just kind of following an order which under the law it has to follow with. Is it then still controller? There's a question mark in that relation. Personally, I believe it can still be considered as a controller, because even if, and we'll talk about this in a moment, the Data Act is to be understood as a legal in relation to the access to user without third parties, in itself as a legal obligation, meaning looking at GDPR, the data holder is subject to this request. It needs to grant access to the data, and it understands this request as a binding request, you know, under Article 6, 1F, 1C, right? That in itself doesn't make you not become a controller. I mean, think about you as an employer, right? You are subject to many legal obligations, for example, to hand over certain employee data to the Social Security offices. You are under the duty to comply with these legal obligations, but are you then suddenly acting not as a controller simply because you are under legal duty? No, you are the controller. In that relation, you simply have to comply with other laws outside of the GDPR, but which are received under the GDPR and ingrained under GDPR under Article 6.1f. So I think it is likely to assume that the data holder is also a controller. But what about, and here I kind of already established this, what is the user in most cases? If the user can have access to the data, and again, under the Data Act, the user needs to be granted access generally to the data, the user has access to the data. It can determine the further purposes of the use of the data. It can use it for own personal purposes. It can hand it over to third parties, in which case likely the user would qualify also as a controller, in particular when it does make such a request for the data. But the question then is, are they joint controllers? And I don't want to go into the kind of all the case law of the European Court of Justice regarding joint control, which I find really, really hard to apply. It is pretty much without borders. But here we have to kind of see that a joint controllership, you know, requires generally a kind of conscious common effort to determine the purposes or means of the processing. And is there's really kind of a conscious effort? The joint controllership itself, in order to become a joint controller, doesn't require an agreement between the parties. That's a consequence of being a joint controller under Article 26, right? But if there's two parties that don't have such an agreement, but which nevertheless kind of jointly determine the purposes and means, they are considered a joint controller. So the fact that there is no agreement between the user, or maybe no agreement between the user and the data holder, doesn't speak against the qualification as a joint control. But in particular, when it comes to the kind of data access, I believe that there's, to me, it seems like there's no compelling reason to assume that they really kind of jointly determine the purposes and means in this aspect. The data holder is obliged to hand over this to fulfill the request, again, subject to GDPR. So that's why I believe, and that's, as I see also the prevailing view in the legal literature so far, there is a separate controllership. So we have got two different independent controllers. On the one side, the data holder, which has access, factual access to the data, and then the user who can request access or has access himself via the system as well. But that doesn't mean that there can be no joint controllership in general. If they both really enter into an agreement about the common usage of the data, then they certainly can qualify as joint controllers. And that seems to be also the view of the European legislator, because it clearly stated in recital 44 of the DA that these parties can establish a joint control, which again also speaks against the perception that they would qualify as joint controllers straight away. So to sum up, in these cases, most times there is no joint control. They're separate controllers in relation to the data, but they can become joint controllers if they want to and if they kind of fulfill these requirements. So right now, kind of take a look at an individual kind of case, so to say. We have got a user who requests access to the data on behalf of to a third party. So someone has bought the user's permission. He is interested in the data, and the user says, "Okay, you know, you can do so." And this third party, with the authorization of the user, then reaches out to the data holder. Again, think about this car manufacturer or the kind of IoT device owner. and they request access to the data. If there is no personal data involved, it doesn't matter. We don't have to look at the GDPR. If the data only relates to data, or only relates to the user, him or herself. So if the user is an individual, it's also fine. We have to understand which rights then apply, but it should not be an obstacle. It's simply a question of which legal basis under the GDPR then applies. Again, the Data Act doesn't claim that it provides for the legal justification for any processing of personal data. So if personal data of the user is involved, the legal justification for the sharing of the data doesn't come from the Data Act. So we have to look into the GDPR, and there are several legal justifications that can potentially apply. First and foremost, I would say it's likely consent, right? Because if I, driving the car, owning the kind of car, and wanting to kind of get access to the data because it's only me, it's only data relating to me, no one else has driven the car, then I request the access to the data, and implicitly I'm giving consent to hand over the data. One can also think otherwise. One can also think, look, the Data Act already provides for the legal obligation of the data holder then to hand out the data and to the user. And in this specific context, the Data Act also doesn't make specific reference to the GDPR. It does so in a different context. So when there's a third-party person data involved, then the Data Act clearly says, but take a look at GDPR. Here, the Data Act doesn't do so. So again, one can kind of perceive and understand this obligation to hand over the data under the Data Act as a legal obligation, which doesn't justify the data transfer, but which can be perceived as a legal obligation within the view of Article 6(1)(c) GDPR, legal obligation of it. One can have a different view on this, but my view, it seems sensible, and because in particular the legislator also under the Data Act made this differentiation. And alternatively, one can also take a look at whether Article 6(1)(f), the balancing of interest, is an appropriate legal justification for the transfer of such data. First and foremost, there seems to be a legitimate interest, right? Because it's indicated under the law that there needs to be such a data transfer. Again, this doesn't surface. Of course, you need to bend and balance the different interests, but there would be a legal justification for it. In my view, the most easy way is simply kind of to think about a consent if I'm the user and doing it. But the problem's really there when the user wants to grant access to data held by such a data holder, and when one is either not sure or when it is very clear that there's also personal data relating to third parties. And then right now it becomes really tricky, and here may be really a big burden in the Data Act, because again, the Data Act wants to facilitate the sharing of data. At the same time, it doesn't provide for any solutions in relation to it, because it simply kind of refers back to the GDPR. So again, we need to kind of understand what is the overlap here. The Data Act then clearly says the data holder is obliged to hand over the data, but only if there's a legal justification under the GDPR, taking obviously into respect that there's third-party personal data involved. So it refers entirely back to the GDPR, and we are back at the start in Article 6. So again, we can understand if this article, does Article 6(1)(c) apply? If Article 5(7) under the Data Act was a legal obligation regarding this, then it would be relatively easy. Then one would say, look, there's obviously a legal obligation. As a result, we can look into 6(1)(c), and then there's overlap, yes, but we have got a uniform, clear approach because the Data Act already provides for. That would be too easy, and it would clearly contradict what the Data Act says, that it doesn't want to kind of create own legal rights in relation to personal data. It leaves it open to the GDPR in this aspect. And unlike in the situation which I discussed before, where the user himself only requested his own data, Here, under 557, the Data Act explicitly refers back to the GDPR. So that would be too easy. So then we have to kind of think about other legal alternatives. One can certainly think about consent, but we all know how difficult it is to obtain legally valid consent. Is there an agreement, 6b? Most often not, right? I mean, the agreement between the user and the data holder, one can think about an agreement there, doesn't justify the transfer of third-party data to someone else. Also not the agreement between the user and the third-party recipient who wants the data. Also not the agreement between the data holder and the third-party recipient, because it's not an agreement entered into with the individual whose data is being transferred, right? So we cannot rely on this. Likely in most cases, we will just be stuck, I would say, with Article 6.1f, so the balancing of interest justification. That's, as we know, kind of is the solution to all, right? Because it gives us leeway a little bit to argue whichever way we want. No. But the Data Act, we need to understand how 6F has to apply it in this respect. One can certainly say that because of this, without prejudice in the DA doesn't want to kind of influence the decision-making at all, right? Then we would have to find a legitimate interest under Article 6.1f outside the scope of the DA. That's difficult. Right? It's not impossible, but it's difficult because the DA already kind of serves the generally perceived legitimate interest, actually by the legislator, to share data, right? So I would say at least already this itself should serve as a legitimate interest. It doesn't lead to the entire justification because we have to balance the different interests also with the individuals, right? But it serves a legitimate interest. That's questioned currently. Some others argue simply kind of by saying, look, the Data Act doesn't want to touch, doesn't want to introduce any kind of legal obligations or rights in relation to personal data. So we need to kind of leave this entire Data Act outside the scope of it, which is then really difficult because there's a legal obligation on the one side, and on the other side, there's a huge hole referring back to the GDPR. And in my view, one can therefore kind of refer to the legitimate interest as pointed out by the Data Act. But then we need to undergo the entire balancing test, right? And that will make it extremely difficult. So we have to understand, first of all, the sensitivity of the data of the individuals involved. We need to kind of take a look at the precautions of the Data Act, that is not the Data Act, the precautions in relation to the use of the data. And it will be really interesting to see how these agreements between the data holder and the data recipient will be set out. So the Data Act provides that the agreement needs to specify not only the extent, but also the kind of conditions of the data transfer, the further use of the data, right? Again, as I mentioned, it is excluded that the data should be used for any competing services. But such an agreement from a privacy perspective, which should really also entail a very condensed set of measures to protect the personal data for any further use, which is outside of what is reasonably expected by the individual whose data is being transferred in that case. The more of these kind of precautions you put into the agreement, the better and the more easy you can overcome the barrier under Article 16F. But you already understand the kind of purpose and goal of the Data Act here to really facilitate the sharing, to create a data economy, which I think is really right, is to some extent really undermined by the very fact that actually the legislator did not go so far to really kind of set the requirements very specifically for the sharing of the data. It doesn't address the specific situation. It doesn't even indicate whether this situation itself is to be considered a legitimate interest within the context of 16F, and leaves it entirely open to the GDPR and to the balancing of interests done by the individual controllers. That is, in my view, not very helpful, but it is what it is. And again, also going back to what we initially discussed, whenever you cannot differentiate between the data, also non-personal data will fall under these requirements, which again can lead to the fact that actually kind of you are further limited in the way you process certain data and share certain data than you were even before. And what happens if if you are in the situation of the data holder, so what do you do in such a case? I mean, oftentimes the data holder may be inclined not to share data, right? Because it's the data that the data holder has created. I mean, that's set up. Think about the car manufacturer. It's really spent billions sometimes into setting up the services, and certainly wants to use the data for the further research of own products, for improving its own products and services, for tough competition in the market. So there's generally an inclination of a data holder not to share data with third parties. I mean, it's not compelled again to share data with competitors, but also generally it doesn't want to have data. So the kind of natural first inclination would be to say, oh, there's privacy. We can do so. And how to really overcome this barrier then, right? I mean, simply by saying, look, as a precaution, I don't want to hand over the data because I'm not really convinced that this can be done in compliance with GDPR, is likely not compliant with the Data Act. So effectively, the data holder who would then be overly cautious, who would err on the cautious side, would likely violate the Data Act. And at the same time, if it is too prudent and easily kind of hands out over the data, it will violate the GDPR. So it's really kind of stuck in between. And it is also really questionable of how these discussions can enter and play out really in real practice. Because again, there's differing views, there's differing incentives, different motives, right? The user likely gets money for sharing the data. So the user wants the data to be shared. The individuals are not even asked. Most times they cannot be asked who are impacted. The third party who is paid money wants the data. They are also willing to pay data to the data holder. So there's really a strong incentive on their side. And then there's the data holder who by law is required to kind of comply with both laws, but has likely an own interest in not sharing data oftentimes. So how to resolve this quickly in a commercially feasible way? That is really up in the air. So we went already through the kind of different clauses here. I think that is exactly what I discussed already. The third party, the legal obligations, as I mentioned, legitimate interests. And what I personally, when looking at the Data Act, would have really kind of liked is kind of, at least in the recitals, to get more guidance on this way. I mean, what's the legislator's view? Should, if in doubt, really the legitimate interest be a strong one to share the data? What specific measures companies should be doing in order to protect the data, but that's all really kind of left open. And last but not least, we have got the question of the competent authorities, and that's something that you already kind of mentioned. There's again an overlap, very likely, right? I mean, the member states shall designate one or more competent authorities to be responsible for the application and enforcement of the Data Act. And if they have designated several authorities as competent, these authorities must cooperate in the performance of their duties. So they must, again, talk to each other, which is an important factor. And in order to facilitate this, the member states shall appoint a data coordinator to coordinate the cooperation. So yet another entity, which requires a lot of actions of the member states. And then there's a limitation under Article 37, Para 3, which says the data protection supervisory authorities shall be responsible for monitoring of the application of the Data Act insofar as the protection of personal data is concerned. And again, knowing that oftentimes when data is intermingled, when data cannot be separated, that the data protection supervisory authorities would be competent for it anyways. Likely in many cases, the data protection supervisory authorities will be also competent for the application and sharing of data under the Data Act, which makes it really difficult. Then we've got specific authorities, the Commission, the European Central Bank, or the European bodies. The European Data Protection Supervisor will be taking care. That makes all really good sense. But the question really is, and I would like to kind of open up the discussion in that aspect, with all the coordination, which obviously is required, but with also so many different acts, and we're not talking only about the Data Act, about the GDPR, we're talking about the AI Act, the DSA and everything. in reality, what does it really lead to? Do we really get a more uniform approach which we can handle in practice? What if we challenge it? Or is it kind of really whole, where basically if you don't want to do anything, you raise the right questions, triggering a lot of mechanisms to coordinate, and then we simply don't get any solution to it. So I do see really a huge risk in the kind of play and between all these different acts, and in particular the supervisory authorities, that effectively in many cases, we will not get solutions because the supervisory authorities cannot decide themselves. It's already difficult. You know much better than I to kind of establish an own view within your own within your supervisory authority. But here you can decide, right, in the end. But then talking on the national level with so many different supervisory authorities, talking on the international level and coordinating the approach, that's a very political question most times, and oftentimes there is simply no straight answer to it. So what I do fear for the private companies is that without really further guidance in that regard, even if we reach out and seek guidance, we will not hear back maybe in a few years, which certainly kind of doesn't aim the purpose of or serve this purpose of the DA. And with that, I would like to conclude and open up the floor and happy to take questions.